Hi, I'm Karen Cole from Legal Minded Friends, and today's question is, if I have an employment case, where am I better off to go, to the civil courts or to the Employment Tribunal service? So it may surprise you that the Employment Tribunal service is a court. However, there are some pros and cons to which court you use. So if you'd like to know some of the differences, please listen to the next part of the video. I'm going to explain three major differences in my view with using a particular court and which court you should use. So for example, 1, civil claims are money claims under breach of contract, and this can be brought whilst you are still employed or within 6 years less 1 day from the date the breach took place. In contrast, the Employment Tribunal can only hear a breach of contract when your employment has ended, and this can be because of you being fired or you quitting. With the Employment Tribunal, you must have an ACAS certificate within 3 months less 1 day from the date you were last employed. However, in a civil money claim, you must do a letter before court action to your employer, giving them 14 days to make right. A good example of this is if you're due a bonus, but you haven't been paid, but this is open to interpretation, then the civil courts might be your best bet. With an employment tribunal claim for wrongful or unfair dismissal under your statutory rights, you must have been employed for 2 years less 1 day to claim, unless you are claiming a discrimination under your protected characteristic rights. An example of this would be, let's say your employer says you have to do some heavy lifting, but you are pregnant. So you decide to quit because they threaten you to fire you if you don't do it. So you give your immediate resignation. However, when you get to court, you cannot prove when you told your employer you were pregnant. So their defense would be they didn't have the information. So unless you can prove that they did know you were pregnant, you could lose the case. Some pros and cons regarding the Employment Tribunal is that you are less likely to be ordered to pay your employer's legal costs if you lost your case. However, the downside to a tribunal is they cannot award you as much if you win because the awards are capped. A pro for the civil court is that they are much quicker than a tribunal. However, the negative is that the procedures are more formal than the employment tribunals. The other issue to be mindful of is the legal limits that courts have, and this can only be really addressed once your case has been reviewed by someone legal-minded. You may feel something is unfair. For example, an employer does not have a legal obligation to pay you sick pay if it is not part of your contract. But if you've not been given a contract or terms and conditions regarding your employment within 2 months of working, you would be able to bring a claim against your employer under the grounds of a statutory requirement that they have not fulfilled. Employment law is very complicated. Another example, if you're not giving accurate information that you need to rely on, and then you find out that you haven't said something that you should have said. An example of this would be that you did not know you were entitled to holiday pay whilst you were on maternity leave, or some other kind of parental leave from bereavement or paternal leave. And there's nothing worse than a judge saying, "I cannot award you because you have not stated it in your original claim." So as you can see, employment law is very difficult, and you really should get legal advice before you quit your job or before the problems start, because more cases are settled outside of court. It is more likely that your employer would like to settle matters with you if they have an opportunity to negotiate with you. If this information has been useful to you or someone you know, please like and share, and contact legal-minded friends if you need legal help as a litigant in person.